Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we are dealing with a brand new order that just came down today in the ongoing lawsuit between JLM and Hayley Paige Gutman. Hayley Paige Gutman was a wonderkin designer recruited by JLM in college and brought into JLM in order to design wedding dresses and other accessories that might be related to weddings. She apparently was very good at her job and designed dresses that apparently were very popular. Indeed, she was featured on the show, Say Yes to the Dress. Unfortunately, things have turned out not so great for her because the relationship between her and JLM soured, causing her to leave the company. Although she left the company, her name stayed behind because part of her contract with JLM was to assign her name to the company so that they now have that asset. And it is not exactly uncommon for companies to be named after people. And then when you sell the name of the business, you're selling your name and then you can't reuse that name, even though it's your name, because you named the business after you. See, for example, McDonald's, named after the McDonald's brothers, who are now no longer in control of the company, which continues to bear their name, as perhaps the most prominent example. In less prominent examples, we bring us to Hayley Paige Gutman. So the district court has taken a look at the orders dealing with the whole name issues and issued a revised injunction. So we're going to read this and discuss what it has to say, so let's go ahead and get started with this. So I will take note just before we read too much more. This is a revised injunction. There was already an injunction in place in which she lose. And so now we're just going to modify it a little bit around the edges. So let's go over the background. Okay. So here's what happened. Gutman entered into an employment agreement in which she agreed to work for JLM, a company involved in luxury bridal design and manufacturing, as a designer of brides, bridesmaids, and evening wear and related apparel. The employment term under the contract concludes on August the 1st, 2022. One will note that date is coming up soon, and one will also take note that she's not working at JLM at this time. The contract provisions that are material are as follows. So in all good things, let's start with the contract. So what provisions do we have in place? Well, we have a covenant not to compete. I'm not going to work against you. Employee covenant agrees that during the period of employment with the company, employees shall not compete with the company directly or indirectly. And then it goes on to define what exactly that means. It agrees that she will not directly or indirectly, during or after the term of employment, disclose to any person not authorized by the company any of the company's confidential information. So anything she learned from the company, she can't take with her because it's the company's information. Okay, then the one that is the biggest trip up of this lawsuit, and really the reason this lawsuit exists, is the issues over the name. What does the contract say? Well, it says employee, that would be Gutman, hereby grants to the company, that would be JLM, the exclusive worldwide right and license to use her name, Hayley Paige Gutman, Hayley Gutman, Hayley Paige, or any derivative thereof, in connection with design, manufacture, marketing, and or sale of bridal clothing, bridal accessories, and related bridal and wedding items, including all goodwill, throughout the term, plus a 2-year period following the term, or any extension thereof. So one might think that they only get the rights as long as she's an employee, and for 2 years thereafter. So is she free in 2024? Well, no, not so much, because in addition to having naming rights, we also granted trademark rights. Oops. The employee hereby irrevocably sells, assigns, and transfers all right, title, and interest to the company that now exists or may exist during the term and for a period to after, to register any marks. Although the period for registering marks will expire, the trademarks themselves shall exist in perpetuity to be exclusively the property of the company. The employee having consented to filing by the company, employee thereof shall have no right to use the trademarks, designer's name, or any confusingly similar mark. So that's basically the big problem. She has signed away all her trademark rights. She agreed to the company, hey, you get the right to register any trademark that's relative to these names. Your right to file new trademarks will expire in 2024. But any trademarks you do register exist forever. That's what in perpetuity means. It means forever. So yeah, that would be the problem. In the event that the company files an application to register a trademark, employee agrees that for a period of 5 years, she shall not identify to trade or consuming public as the designer, and her role as designer shall not be used to promote the sale or any goods in competition with goods manufactured and sold by the company. Yeah, so she can't mention the fact that she designed the clothes named after her, and she can't use that in any way to compete against her former employer for a period of 5 years after she leaves. And then there's a very long provision that basically says anything I did in the employment with you is your thing. It's a work for hire. Section 11 is just a big ass work for hire provision. While I worked for you, all the things that I did are your intellectual property, not mine. Great. Okay, so after entering the contract, Miss Gutman opened an account on Pinterest and an account on Instagram, both bearing the handle Miss Hayley Paige. Oh, that sounds like that's kind of similar to the names that we assigned the company. I see the problem. Miss Gutman offers that Miss Hayley Paige is a term of endearment for defendant used by her mother. Okay, Miss Hayley Paige, however, is a version of the designer name. Explain that Miss Hayley Paige and Miss Hayley Paige are derivatives of Hayley Paige. Seems kind of reasonable. You did assign the company all derivatives of your name, so yeah. The biographical information displayed on the Instagram and Pinterest accounts has changed over time. The evidence of record shows the Instagram account has included links to HayleyPaige.com, PupUpPage.com, HeartsOnFire.com, and to JLM Couture /trunk shows. The Instagram account also regularly included references to JLM's email address, was linked to JLM's Facebook page for a period of time, and at times included links to free downloads at Holy Matrimoji, which reference a collaboration between JLM and a cool jewelry company, Hearts on Fire. Okay, so this is going to be a problem, right? So one thing we have is the name itself, which appears to be derivative of, her own name, which, yeah. But maybe it's still not a business thing. Maybe it's personal anyway. Maybe we can get past the fact that it, was her name and that seems to be derivative of her name. Maybe we can get past that and say, hey, no, this is actually personal, not business. Well, the problem with that argument is that the accounts from time to time linked to and included things from JLM. And so, including JLM's email address, including campaigns that JLM was part of, and so forth and so on. So, she didn't operate it as a purely personal account. She operated it as an account that went on to, at least in part, market for JLM. So, if we were somehow going to read past the fact that it's her name, and that seems to be derivative of her name, if we were going to look past that fact, the fact that she's in fact operated the account as a business asset of JLM is going to pose an additional problem. Yeah, if there was ambiguity, the ambiguity is disappearing. In or around November 2019, the Instagram account included the description designer, creator, emoji maker. In or around February and November of 2022, the Instagram account included the phrase personal and creative account of designer Hayley Paige. Okay. The account was also verified by Instagram as an account of a public figure. Okay. After the TRO was issued, JLM removed Gutman's image from the profile picture of the Instagram, changed the biographical section of the account by replacing public figure to clothing brand, deleted defendant self-description, and reinstated plaintiff's website and PR link. So as part of the ongoing court case and the prior injunction issued in this, JLM got control of the accounts. They then did what you would expect them to do. scrub them of any reference to Miss Hayley Paige, and turn them into a pure corporate asset. Yeah. JLM also changed the title of the Pinterest account from Hayley Paige to Hayley Paige Bridal. That's also derivative of her name. No problem. A current version of the Pinterest account reveals it remains under the handle Miss Hayley Paige, maintains a picture of Miss Gutman in white gown, links to JLM Couture Hayley Paige, and contains the description, "Hi, I'm Hayley Paige. I'm a designer, content creator, and podcast host for all that glitters, but mostly I'm just grateful." So maybe now the problem is reverse. Maybe now that the company's in direct control of the asset, maybe the problem is reversed, because now they're not running it purely as a company asset. They seem to also be using assets that might be personal to Hayley Paige. So maybe we have the reverse problem. When she had the account, she was operating the account both as a personal and business account. When they have the account, maybe they're doing the same thing. Maybe that poses a problem. Let's read on. Gutman proffers that she was an earlier adopter of social media and opened the Pinterest and Instagram accounts on her own accord for her own reasons. Yeah, but maybe they morphed into something else along the way, which is, yeah. With respect to the Instagram account, Gutman submits she opened the account based on the suggestion of a friend who told her about the platform and how much she loved using it, and sent Gutman a link to download the Instagram. So she says she opened the account because a friend told her to, not because the business told her to. My motivation in opening the account was not that JLM said, create these accounts. It was rather my friend said, create these accounts. Well, that might have been your motivation to do it, but whether or not they are assets of the company doesn't necessarily stop there, because we're going to go to the contract language. Like, why you did a thing is interesting, but we're going to start and quite possibly stop with the contract language. The contract language is definitely going to be our dominant aspect. So sure, that's the reason you did it. Do we care? Not necessarily, not that much, no. Miss Gutman linked the Instagram account to her personal Gmail account and a personal cell phone number and created her own password. She linked the account to her own email address. However, she used this email address for business purposes, including with correspondence to her work. See, things are getting mixed up even at the beginning. So the nature of what this thing is confused even from the very beginning, and it's going to get more and more confused along the way. The evidence shows the Instagram account was utilized to showcase JLM's products almost immediately after creation. Mr. Murphy, the president of CEO and of JLM, proffered testimony that opening of the Instagram account was timed to coincide with the week of the New York bridal market, which is the largest, most important market. So JLM isn't necessarily willing to concede that Hayley Paige opened it for purely personal reasons. JLM says, well, no, maybe she opened it because we asked her to, which again may or may not be dispositive of the issue. But whether or not she was told to by the company or whether she did so on her own might be a factor that we would have to consider in determining whether or not this is a corporate asset or a personal asset. So if she's told to do so by the company and she does it, does that necessarily make it a corporate asset? No, it doesn't. Just because a company tells you to do something doesn't mean that the thing that they create is theirs, right? Again, this is going to be largely driven by contract. So just because assuming JLM told her to do so, just because JLM told her to do so does not end the equation. And also the reverse is true. Just because her friend told her to do so does not end the equation. Those pieces are at best evidence that would help inform our decision as to whether it's a corporate or personal asset. But ultimately, this thing is going to be driven by the contract. Be careful about the contracts you sign, basically, is the bottom line of this entire analysis. The opening collection of posts on Instagram reveals Gutman posted several photos of bridal designs within 2 weeks after creation, including 2 photos of bridal gowns, 1 photo of a bridal gown, and 2 photos of bridal accounts. Several of the photos posted to the Instagram accounts were from shoots and trunk events where Hayley Paige dresses were being sold. So the photographs weren't hers. They were photographs being taken of events that she was appearing at responsive to her duties, and possibly not even taken by her. These additional facts, to the extent we care, are going to influence our analysis. In the event the contract language is vague or unclear, then the behavior of the parties becomes more relevant. So we'll just describe all the facts that are there. Then we'll do the analysis, right? So first we describe the contract in the contract language. Now we're describing the behavior of the parties. The behavior of the parties may or may not be irrelevant, but we're going to describe it anyway before we figure out whether it's relevant. But to the extent we care, here's some facts. Okay. The proffered collection of posts to the Instagram account within the first year of account creation also confirms Murphy's testimony that there was a break-in post where the last post showed a sparkly handbag, and a different post where the first post after a 3-month hiatus shows a rack of bridal gowns. So there was a period where nothing was being posted to the Instagram account during this 3-month period. The last thing that happened before this 3-month period was business related. The first thing that happened after the 3-month period was business related. Nothing personally related happened in between. This is suggestive of a business asset. Mr. Murphy explained the renewed efforts coincide with time in which spring shows were being launched, and at that time, having content to post again, Gutman began posting about it again. Plausible. Indeed, 20 posts displayed in chronological order showcase wedding gowns, including photos of models wearing gowns, what appear to be behind-the-scenes look at photo shoots. I'm going to go out on a limb, and I'm going to assume that Gutman herself didn't take any of these photos. I'm going to assume the photos are assets of JLM. The fact that she's posting JLM's photos on her account might be indicative it's JLM's account. The court reaffirms his previous finding the Instagram and Pinterest accounts served as a critical advertising platform for JLM. As the court has already found, this approach included featuring pictures of behind-the-scenes activities at plaintiff's photo shoots and events, and also described pictures of vendors selling or bridal wearing gowns. The Pinterest account includes collections of pins, showcasing particular collections, including Blush by Hayley Paige, as well as collections focused on individual gown designs. JLM has also identified its goods with reference to social media platforms by putting the Miss Hayley Paige on the hand tags of physical garments and including social media references in its own print advertisements. This is suggestive that JLM thinks it's their asset. They could, of course, be wrong, but it's suggestive that JLM thinks it's their asset, just as, for example, that Hayley Paige posting personal things on the account is suggestive she thinks it's her asset, right? These things are suggestive of whose asset it may or may not be. The fact that they are including her Instagram handle on physical tags attached to the merchandise and in their own printed advertisement is somewhat suggestive it's a JLM asset, in case there was confusion. Yeah. Ms. Gutman expressed a desire early on in her employment at JLM to assist in leveraging social media to market the brands. I'd like to take note here at this point, by the way, that this is the trial judge at this point speaking. And we're in preliminary motions. And the judge is, of course, the finder of fact. So for the purposes of our present exercise, at least, these are facts now. So there's that. On September the 27th, a little more than 2 months after entering the contract, over 1 month before she opened the Pinterest account and several months before she opened the Instagram account, Gutman sent an email to a JLM employee asking them to let me know when I can start helping with Facebook and Twitter pages, as well as the blogging. At this point, I neither know nor care what a blogging is, but that apparently was a thing. I'm assuming that that's just not the name of an asset, and she just means, how can I help with blogging? I don't know. Maybe it's the name of an asset. I'm going to move on. In another email exchange between Miss Gutman and Mr. Murphy, Miss Gutman expressed her desire to take classes in video editing because our generation is responding to people that really work with social media, and classes could really give a leg up on other bridal companies and help us drive more traffic to our website, store, in LA, Pinterest, and Instagram pages. Gutman explained she decided to assist JLM in implementing a social media strategy because JLM's efforts were subpar and disorganized, and through her efforts, they would be mutually beneficial for more exposure. Cool. But yeah, who owns all that at the end of that? This is what happens when you mix corporate and personal assets. This is just a word to the wise, just generally speaking. This also applies, incidentally, to financial aspects. If you have a corporation, you should make sure to segregate corporate funds from personal funds. This kind of thing is what happens when you don't do that. This is also the kind of thing that happens when you don't segregate personal assets from corporate assets. When you combine and mix corporate assets and personal assets, whether that's money, which is how this most often arises, which is the reason I'm mentioning it, because that's the context in which this kind of thing happens the most often. Now we have an account that's both doing both personal and business stuff, and now we have to undo all that or figure out what's what, and it's a total pain in the ass. But not just money, although most often money, but not just money. When you are mixing personal and corporate assets, now we have to have a discussion about whose is what and all the rest of it, and it leads to problems. Don't do this. It's a bad plan. Ms. Gutman explains that she decided to assist JLM in implementing a social media strategy. We read that part. Gutman and JLM's employees work together to strategize as to how best to leverage the social media platforms to market the brand. For example, Gutman participated in discussions with JLM employees about how to best use social media to boost sales, promote trunk shows for Hayley Paige dresses, and increase brand viability. In one email exchange, Gutman wrote to JLM, in an effort to help sales, I'd like to implement a more efficient method for aligning trunk shows and stock hitting our stores with our posts on Instagram, and expressed her view that our stores need a little more help boost on social for filling appointments and getting HP-specific brides to their stores. And an individual on board at JLM can coordinate with our sales team on a weekly basis for things to be posted throughout the week. It's important we can continue this current action for posting trunk shows on Tuesdays to HP and Blush Instagrams. Yeah. In other example, Gutman discussed strategy of changing the standard trunk show post to potentially include a swipe up link on Insta Stories to our website to view the whole collection, and weighed in on how to use promo codes to use Instagram for limited time only. With respect to Pinterest, Gutman discussed strategies for pinning, PR clips and mentions, pinning trunk show posts on our at Miss Hayley Paige and JLM Pinterest pages. Again, not necessarily dispositive, but not exactly helpful when you want to turn around and say, that's mine, and you have an email that says it's ours. This is where confusion comes from. Yeah. It's important when you own an asset to make clear that it's your asset. If you have people that are helping you, yeah. And yeah. This is, yeah. The Instagram account, which permitted account followers to send messages about account content, was also utilized in communication with actual and potential customers. Followers saw pictures of the dresses on the Instagram account and messaged the account to inquire further about potential design changes, prices, and where they could find JLM products. The customers are using the accounts for business reasons. To the extent there's ambiguity in the contract, this behavior is suggestive of what the purpose of the account is. Yeah. After the trunk show or during a bridal market, I received a large number of sales requests on my personal Instagram. Is it a personal Instagram, though? Miss Gutman wrote a store representative that reached out to her via Instagram, and the majority of questions are sales, including sales stuff, gown stuff, bridal stuff, and favors. Gutman asked a GLM employee, do they have any interns this week? I would love if they could go through my last 5 Insta posts and ask any necessary sales questions. Uh-oh. So you said it was your Instagram, and then you also said, hey, JLM, do you have any interns that can go through the Instagram to answer sales questions I'm receiving relating to the business? There are problems here. In response, customers were provided with answers to their questions about JLM products or directed to JLM resources, including the email addresses of JLM staff members and links to JLM's websites, such as a link showcasing JLM's upcoming trunk shows. Yeah. Miss Gutman emailed JLM employees saying she answered 250 messages today alone. I actually sent this bride to HP's email. I'm only sending the best bride that seems serious about shopping or wanting to order your way. Oh joy, she's selecting which people to forward to JLM based on her perception of what will be best for JLM's business purpose. Are we sure she's not operating the account on behalf of JLM? Ms. Gutman also utilized the account to garner customer information and provide customer service. In one email exchange, Gutman reached out to JLM employees about a super unhappy Instagrammer that ordered whatever, which was not correct and was damaged. Ms. Gutman stated she needed to do a new sketch. And, whoa, can you help with the address and make sure it goes out tomorrow? If we don't have the address on file, I can ask her via Instagram. She's doing customer service on her personal Instagram account. So is it a personal Instagram account? The behavior is muddled at best. Ms. Gutman approached social media at JLM in an inclusive way and offered to involve JLM employees in her decisions. She says, quote, in her own declaration, I do not dispute I occasionally sought JLM's input on posts. She sought JLM's input on her posts on her quote-unquote personal Instagram. JLM proffers she requested JLM's input and guidance for content that was either particularly sensitive or directly impacted JLM so that Ms. Gutman could represent JLM's needs and wants in an agreeable way. Could represent JLM's needs and wants. For instance, a JLM employee emailed Gutman directing her to a website and noting they added a slash to the address, to which Gutman said, wow, can I share on Insta or is that too risky? Interesting. You're asking the business for permission to post on your own Instagram account. You're asking for their permission. Are you guys seeing the problem? We have a twofold problem here for Miss Gutman. Problem number 1, the contract. Problem number 2, to the extent the contract is ambiguous, behavior of the parties. How are the parties behaving? How is Miss Gutman treating this personal Instagram account? Yeah, you see the problems? This is a cautionary tale on what not to do. The overall cautionary tale is, as I said before, do not mix personal and business assets. You run into problems. Usually it's money, but as we can see, not only money. As the court has previously found, Murphy suggested Gutman say something about a Manchester event in the aftermath of a terror attack, provided a draft caption, told Gutman to wait on Instagram to do more posts until England wakes up, which apparently then she did. Yeah. The record also demonstrates amply that JLM exercised a degree of influence over Gutman's social media activity beyond whatever particularly sensitive situations are. So maybe, okay. So this would be like another idea we could try as a lawyer, right? All right. It's still a personal account. I only came to JLM when it was really, really sensitive stuff because I wanted to make sure, not to harm our business relationship. So I wasn't really seeking their permission exactly. It was just that, I wanted to make sure not to defame them or something. So it was so I wasn't really seeking their permission exactly. So it's still a personal asset. Well, okay, but yeah, not so much, because it was only limited to that. It was also to the general promotional efforts. The argument that this is a personal asset is getting harder and harder to maintain every moment. For example, JLM employees provide Gutman with directions about content she should post in accordance with a week-long promotion event held by JLM. For example, JLM told Gutman that she need face-to-face individuals for each day of the week, and that you will announce that we're having 4 days of promotions on popuppage.com, and they need to stay tuned to your Instagram stories each day to see what they were, and including promo codes Gutman was to promote throughout the week, and to which Gutman responded, "Can we make the promo for all of the athletic instead?" Uh-oh. In another example, when discussing the stylized shoot and the need for model, Gutman acknowledged that she would love to find a real bride or influencer on Instagram and wouldn't be opposed to doing a post on social media to ask if anyone's interested, but would need to ask Joe, that would be JLM, on how to do it properly. The court also previously found Gutman corrected an Instagram post to include a boutique selling JLM goods at plaintiff's request, and in another instance texted Murphy to ask his permission to post to Insta or wait. This, by the way, at this point, we're talking about routine business posts, not these super sensitive emergency post things. Now we're talking about regular, normal, ordinary course of business posts. During at least some periods prior to late JLM 2019, JLM employees directly accessed the Instagram and Pinterest accounts and participated in management of the accounts. They accessed the accounts directly. Between 2017 and 2019, Gutman granted access to the Instagram account to at least 2 JLM employees. Gutman emailed these people along with other JLM employees in order to discuss and delegate potential assignments for leveraging the Instagram and Pinterest accounts. Oh, that's interesting. She's acting as a manager, directing employees now. Yeah. And this is going great. This is going great over here in Gutman in the Instagram and the Pinterest accounts are my assets argument. This is going super well. Super duper well. There seems to be quite a lot of information and facts that are seem to be suggesting to us, maybe not so much with it being a personal account. Oh, I gave them direct control. Oh, I'm giving them instructions on it as a manager. And they're JLM's employees. Okay, good. That's great. And then they give some more examples of specific emails in case, we want the specifics, but we'll skip that for now. For example, in 2018, Gutman emailed the employees noting that they had broken down some assignments and asking employees to let me know if you have issues or don't feel you can participate. They're JLM's employees, though. With respect to Instagram, Gutman allocated these following tasks: posting Hayley with Brittany contributing bridesmaid and Lisa contributing trunk show posts, checking all of DM Brittany and Hayley, checking all comments within each post, Lisa, reaching out to engaged influencers and stylists, Brittany. With respect to Pinterest, Gutman allocates the following tasks: pinning at least one image from every PR clip mention that Brittany sends each morning, Brittany, pinning trunk shows, Lisa. Would love to have you use the same posts you create for Facebook on our Miss Hayley Paige and JLM Pinterest accounts. Organizing boards, the interns, whoever they are. Regarding participation of the interns, Gutman cautioned, if we delegate anything to interns, they're not allowed to know our passwords. You'll have to log in for them. Whose passwords are they? Our passwords? Oh. And she's directing them like a manager. Oh. On at least one occasion, Gutman noted her preference that JLM employees send her drafts for approval, but they gave them discretion to go and post ahead. So they can post directly themselves. Oh. The factual picture is, yeah. Gutman expressed her preference that JLM employees manage engagement with followers and content related to advertising her designs while she focused energy on creating posts reflecting her personality. The biggest help of all for me is staying on top of liking, commenting, and engaging with our brides as much as possible. Gutman also asked for assistance with informative posts, focused on helping our stores, where we can more product, more sales, and press-driven content, but cautioned that she'd like to handle all brand-driven personality posts. Delegation of tasks, assignment of tasks, delegation of authority to JLM employees, to JLM interns. Gutman advocated for JLM to hire a social media director to assist her. In an email to Murphy, Gutman explained her rationale, noting, I feel my effort at Miss Hayley Paige gets distracting, having to comment, respond, keep up with DMs, which Brittany does help with, when she would like to reserve her focus on more personal face-to-camera posts that take a while to create. I'm having trouble managing this asset, boss. Would you consider hiring someone to be a social media director? Because I'm having trouble managing this asset, boss. Boss, could you hire someone to help manage this asset? Because I'm having trouble doing it. Yeah. Gutman's blending of personality with promotional efforts on the accounts embodied an overall marketing strategy for the brands. JLM's approach to the bridal industry is to work with designers to build and promote namesake collections, such as Hayley Paige Collection. This has been referenced by JLM as a personal glimpse strategy in which social media accounts, where a brand name is linked to an individual, such as Gutman, often incorporate posts more personal in nature. So it's part of JLM's design that her personality shine through on this account, as well as that. But that's JLM's design. They want that. So, yeah. Great. As the court found, Miss Gutman and Murphy adopted this approach and worked together. Sure, sounds great, boss. The Instagram and Pinterest accounts reflected a mixture of promotional account for JLM and posts reflecting on Gutman's personality and interests. In discussions about the social media platforms, Gutman emphasized the importance of ensuring the accounts were not focused solely on promotional material, but also reflected her personality. I think it's important we do not dilute this Instagram with too much promotion advertisement so we can maintain the aesthetic and personality of the brand. I think it's important we do not dilute this Instagram with too much promotion / advertisement so that we can maintain the aesthetic and personality of the brand. The brand's personality. The brand's promotion and advertisements. While I'm ecstatic that brides love my dresses, I believe it's my personal approach that makes the personal Instagram successful. Is it personal, though? Is it? Are you sure? Are you sure it's a personal account? I don't know, man. I don't know, man. It seems like we're mixing an awful lot of business with this personal account. I don't know. And we're coordinating with JLM specifically as it relates to the interaction between personality and promotion. You say personal accounts. I'm not sure that you know what that means. You. The court has previously detailed a breakdown in the parties' relationship. We can kind of skip all that part. That things didn't go well at one point, blah, blah, blah. Okay, after the preliminary injunction was issued, the relationship continued to go to shit. Blah, 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 blah. Okay, so, yeah. So that's where we are. That's where we're at. All is not well in the relationship between JLM and Hayley. Things have deteriorated quite badly, and now we're here. JLM has ownership of these Instagram and Pinterest accounts based on the court's finding of fact that take your pick of it is governed by the contract and or governed by the party's behavior. Either way, yeah. Okay, so JLM has moved to modify the preliminary injunction. Okay. First, JLM seeks to extend the temporal reach of the preliminary injunction, which governs conduct vis-a-vis social media account. Paragraph 1 currently prevents Gutman until August 1st, 2022 from making any changes to the social media account that are inconsistent with her duties under the contract without express permission. So seeing as that date's about to come up, we'd like to, continue having the assets, please. Paragraph 2 of the injunction currently prohibits Gutman from, until August 1st, taking any action other than anything that you give notice of the court to gain exclusive control. Again, they are JLM's assets, or they are at least until August the 1st, 2022. And JLM would like to, have that extended now, please, so they can continue being our assets. The relief granted in these provisions was tied to enforcement of the contract, the employment term which expires on August the 1st. So the contract expires August the 1st. So to the extent that they were corporate assets, they were definitely corporate assets during the term of the contract. She may have left the company. That puts her in breach of contract, incidentally. But the contract continues, despite her leaving, because she's the one in breach. So, to the extent they're corporate assets until at least the contract ends. But I said at least until the contract ends because of the provisions we read earlier, for example, dealing with trademark rights, non-competition, so forth and so on. So now the contract's coming to an end. Well, what now? JLM requests the court evaluate likelihood of success on the merits of its property-based claim for conversion, which is basically civil theft, and unlawful trespass chattel, which is kind of also civil theft, to be honest, in support of its request to extend the temporal reach of these provisions past the term of the contract until the merits are resolved. So we're still fighting over, incidentally, whose assets these are. So strictly speaking, we still don't know, because the lawsuit is continuing. In order for us to give an injunction, we have to determine whether JLM has a high likelihood of success on the merits. It doesn't have to be preponderance, because that's the ultimate standard they have to prove, but we have to prove that their standard is high. How high? I don't know. Depends on your judge that day, but let's say 25%. Do we have a 25% chance of winning? Maybe that's too low, maybe it's too high, but pick a number, sounds good to me. Okay. So so the question is here, do we have enough of a probability of winning to keep the injunction in place? Because, of course, if we don't, we have to give it back to Gutman. Now, that doesn't, of course, indicate whether or not we will win or not in the end. But who gets it in the meantime? Which side has the better argument right now? I think you kind of understand where this is going. Third, JLM seeks to extend relief of paragraph 3B, which currently reflects obligation of 9A and prohibits Gutman from competing with JLM by engaging with blah, 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 so the non-compete clause. JLM respectfully asks this court to extend that reach as an equitable remedy in order to compensate Gutman for allegedly wrongful conduct. Okay, so JLM at this point is arguing as to the non-compete provision. JLM is saying, okay, we don't win in contract. We don't have it in contract. But would you consider extending it anyway? For reasons of equity. Because it's more fair. What reasons would those be? Well, for example, the action she's already taken to compete, in which this court has already found to be contempt. So based on her own behavior of attempting to compete with us in violation of order to the point that the court found it to be contemptuous, how about extending that out as an additional penalty? Okay. Further, JLM seeks new relief, incorporating her obligations pursuant to 9C not to disclose to any person any information, including customer lists. Okay. So, conclusions of law. A party seeking a preliminary injunction must demonstrate either a likelihood of success on the merits or sufficiently serious questions going to the merits to make them fair grounds for litigation. They're likely to suffer irreparable injury, the balance of hardships tips in their favor, and the public interest would not be disturbed. A different, more demanding standard applies when proposed injunctions impose affirmative obligations. So there's a difference, at least in this court, between affirmative obligations and negative obligations. Negative obligations are stop doing things. Affirmative obligations are start doing things. Injunctions can order both. Injunctions can be like stop doing this or start doing this. But there's a different standard, at least in this court, as to these things. So if we want to make you stop doing it, we read that standard. But if we want to make you start doing it, well, we can only do that upon a clear showing you're entitled to relief requested, or where extreme or very serious damage will result. So we have a higher burden, again, at least in this court, between the stop doing things and start doing things injunctions. JLM seeks to extend its relief embodied in paragraph, which is set to expire. As previously discussed, these provisions govern Gutman's conduct vis-a-vis social media accounts. On February the 14th of 2022, after reflecting on the Second Circuit's decision vacating the first two paragraphs of the original order and remanding the case for further proceedings, the court reinstituted the provisions in a modified form, tying their effectiveness to the contractual form, finding JLM had demonstrated a clear and substantial likelihood. So as indicated here, we've already been on appeal once, because a preliminary injunction can be appealed. And the Court of Appeals somewhat modified the order. And so, well, that's obviously going to influence what we're going to do now as a court. So we've already been whacked very slightly over the head, mind you. We were whacked very slightly over the head, and we were directed basically to tie certain provisions to the contract term. Now, that doesn't necessarily end the question, because we'd have to get into the very specifics about what the Court of Appeals directed us to do, why, and so forth and so how. But the fact the Court of Appeals has spoken to this question is going to be at least informative, if not downright dispositive, as to what we can do, because, you know, Court of Appeals beats District Court. But it gets very into the specifics of what the Court of Appeals said, of course. All right. The court has not previously addressed the issue of whether JLM is likely to succeed on conversion and trespass to child claims. So previously, we had tied it to some contract provisions, but we hadn't previously analyzed this. With the contract term in paragraphs 1 and 2 to be expired, so not so much that, how about something else? JLM now requests the court evaluate the merits of its unaddressed claims. Which, you know, fine, fair enough, because previously we were able to decide it on the contract. The contract was still running, so we were able to determine this as a matter of contract, right? But now we have to decide, hey, now that the contract is over, are they still JLM's assets? They were assets at least that long, but how about now? Okay. So now we have to evaluate the merits of that. The court agrees the evaluation of likelihood of success on the merits, which turns on a novel question of ownership of the accounts, is necessary and appropriate. So, yeah, now that the contract thing is about to expire, I was able to avoid that issue before, but now I can't avoid the issue because, well, there's no contract anymore. So I have to decide these other issues. So let's figure that out. Okay, so are we going to win or not if we're JLM? Let's find out. To state a claim of conversion, which is where we stole your stuff, the plaintiff must establish that the property subject to conversion is identifiable. If we're stealing a thing, it would be helpful to know what the thing is. Plaintiff had ownership, possession, or control of the property before conversion. So it was yours, and then yoink, I took it from you. And defendant exercised an unauthorized dominion over the thing in question to the alteration of condition or the exclusive rights. Basically, that's my thing now. Or otherwise, I interfered with your ability to control the thing. So I prevented you from using your thing. That's conversion. Neither party disputes that intangible property, such as websites, can be the object of conversion. Which, yeah, sure, of course. Claims of trespass to intangible property, such as social media, have been treated as claims of trespass to chattel by New York law. Chattel is just the name for anything that's not real property, basically. Chattel is personal property. That's all that means. Chattel is all personal property. If it's real property that is land, it's not chattel. Otherwise, it's chattel. So unsurprisingly, the New York courts have previously said, hey, intellectual property assets, also chattel, which, yeah. To state a claim for trespass to chattel, they must allege that they caused harm to the owner's interests in the quality, condition, or value of the chattel, or they've been deprived of the chattel for a substantial period of time. Great. The issue of ownership of the social media account is novel, and few courts have examined this question, which, again, is not surprising. In law terms, social media was invented earlier today. So we're not quite sure about these things because, the entire concept of social media, not these accounts, mind you, but the entire concept of social media accounts was invented earlier this morning, basically in legal time. So there's some ambiguity over how to resolve that particular issue because this hasn't been around very long yet in legal time. So we have to figure this out. We get to be one of the first to figure it out. Huzzah! In his paper supporting the motion, JLM cites two decisions that provide some helpful guidance. That's about what we've got to work with right now. Okay, so in some other case, the issue was whether a Facebook account and Twitter account created by a former majority owner of a corporate debtor belonged to the owner or to the debtor. The court just concluded an analysis to determine whether the account were personal or business assets. Turning to that Facebook page, the court emphasized the following factors. So in that case, how did we determine if the Facebook page was personal or business? Well, the Facebook page, and this is all relating to some other case completely entirely. This is precedent now, just in case there was confusion. All right, so we have to figure out what did we do in the past that might help inform what we're doing now. All right, so sometime in the past, there was some other Facebook page. This other Facebook page was entitled Tactical Firearms, which was the name of the corporate debtor. And the Facebook page was for a business brand or organization, not for an individual person. That's suggestive. The account was directly linked to the Tactical Firearms webpage. That's suggestive. The former majority owner utilized the account to post status updates on behalf of Tactical Firearms that included many expressly business-related post advertisements like its Black Friday sale on new inventory, and included such phrases on behalf of myself and the Tactical Firearms family. That's suggestive. The former majority owner granted Tactical Firearms employees access to post content promoting the company's products, the purpose of which was to create revenue for the company. That's suggestive. The fact that the Facebook page was created in the name of the business, was linked to the business's webpage, was used for business purposes, places it squarely in the category of a business asset. Seems logical. In reaching that conclusion, the court expressly rejected the former majority owner's argument that he had demonstrated the page was personal by proffering the evidence that he started the page for personal reasons. Used it to share personal posts. And accessed it through his personal profile. The court noted at most, this evidence establishes that the former owner conceived of the tactical firearms business as an extension of his personality, and it was utterly insufficient to overcome the presumption that a page entitled Tactical Firearms was anything other than what it appeared to be, a business page. So, yeah, there might have been some personal stuff, but no, not on balance. Thus speaketh the court. After conducting a similar evaluation of the Twitter account in this other case, completely unrelated precedent, the court held that the Twitter account was also business. How did we reach that determination? The court recognized the fact that the Twitter account was named after the business, bearing the Twitter handle Tactical Firearm, including a description of the business, was linked to the business's webpage, raised a presumption that it was business account. For the second time, the court rejected the former owner's definition of personal versus business posts, explaining that the very nature of social media dictates that its best use for business is somewhat more subtle than other forms of marketing, and that a tweet advertising the fact of the owner of the gun store is at a gun show, which was one of the examples that the owner said, hey, that makes it personal. There was a tweet saying, I'd be at this gun show. That's a personal thing. Okay, no. It's a personal example of this kind of subtle marketing, as it was most assuredly served to develop the individual's reputation as being well-informed, connected insider to the gun-buying community, a reputation that would attract consumers to the business of tactical firearms that he was running at the time. So, yeah, kind of a business asset on the balance of considerations of these facts. I think you can kind of tell based on this precedent where this court is likely to go, but let's keep reaching on. JLM also points to factors relied on in some other case from the Eastern District of Kentucky. We will take note, of course, the Eastern District of Kentucky is both, one, a trial court, and two, not in the circuit, so its decisions are what we call persuasive authority, which means we can't ignore it because we're not bound by it, but also it's informative. So it's as informative as the court finds it to be. How informative are we going to find it? Let's find out. So in this other case from this other district court, which we're not obligated to follow, but we could, in this other case says its evaluation of whether a Facebook page and a union member group on social media, both created by former union president, belong to the president or the union. Okay, so the union president created some stuff. Is it the union stuff or their stuff? In granting the union's motion for summary judgment on conversion, the court relied on the decision that we just talked about just now and held that the accounts were owned by the union because they were created to communicate with union members, held out as official union pages, promoted on the union business cards and official website, and other members of the union other than the president had administrative privileges in order to access the account. I wonder how these facts might be relevant to our current situation, one wonders. After finding the former union president had removed administrators and banned certain union members from social media, which interfered with the union's right to enjoy the social media account and communicate with its members, the court determined the union was entitled to summary judgment on conversion. These cases focused on common factors pertinent to determination of whether a business or organization-related social media account belongs to the entity or the individual who created it. Whose thing is it? Whose thing is it? Is it the person who created the thing or the business's thing? Well, to determine that, let's look at some things. These factors include such things as whether the account handle reflects the business or entity name, how the account describes itself, whether the account was promoted on the entity's advertisements or publicity materials, whether the account included links to other internet platforms of the entity, the purpose for which the account was used, including whether it was tied to promotional or mission-oriented activities of the entity, and whether its employees or members or entity had access to the account and participated in management. Now, I will take note of something just because I think it's interesting in sort of how the law develops. These factors were completely made up by the court that created them because there was no law. Because this entire thing with social media and this entire question has only existed since this morning in legal time. So sometime earlier today in legal time, some court had to, for the first time ever, figure out whether it was a personal or business asset with absolutely no guidance of any kind. Now, that's slightly overstating because it is a chattel like any other chattel. We can look to analogies to other chattel. So we can look to things like, how does the law deal with, I don't know, possession of books or possession of like whatever. And so how can those things be analogized to this? And the court just created it out of nothing. And now you have a case in Kentucky which cited those propositions. And now this court is citing those propositions. This is how law gets made, people. This is how law gets made. This is exactly how it's done. This is how our common law system works. Someone comes to a court with a situation that has never happened before. What does the court do? Well, the court looks to the nearest analog, whatever that would be. So the first court's going to look to, how do we deal with questions about who owns a thing when it's other kinds of things? Who owns this chair? Who owns this TV? Who owns these books? Who owns this whatever, right? So we reason by analogy. We create standards. Other courts do that. We begin to coalesce on something that resembles a standard. And eventually, although we are nowhere even remotely close to that at this time, eventually those standards become fixed and they become black letter law. We're nowhere close to that right now because, as I mentioned, it existed since this morning in legal time. And you can bet your ass the other courts in other jurisdictions are going to look to other factors. These factors may or may not be compatible with these factors in whole or part. And the law is going to struggle for a while trying to figure out what is the answer. So there will be conflict. Eventually, these conflicts will become resolved. When I say eventually, normally in legal time, we're thinking something like 20 years into the future. Because we need not only enough time for these cases to be decided, but also other cases in other courts to be decided, and also those cases to be cited by yet other courts to be decided, and so forth and so on, in the hopes of achieving some kind of harmony that will reflect some kind of universal standard. 20 years bare minimum. Whether or not that's fast enough for our current age, well, that's the way law works. So yeah, we're kind of in the middle of this process, and it's early days. It's early days, so we'll press on. But this is what we got to work with for the moment, so let's go with that. The court also concludes that these courts' conclusion that use of the business or entity name to identify an account of the public weighs heavily in favor of finding the account is owned by that entity. Sure, why not? The factors can be distilled into three overarching categories. Categories. The manner in which the account is held out to the public, the purpose for which the account has been utilized, and whether employees of the business have accessed the account. Okay, so already we've got modification of the law, right? Because some court previously said, how about these 6 factors? This court is basically saying, I think some of those factors are the same. I think there are 3 factors. Here are the 3 factors. We're creating law out of nowhere, people. This is how common law works. It's great. Ms. Gutman posited her creation of the accounts, combined with her subjective intention they be utilized for personal reasons, is determinative of the ownership. She argues that activities of the post-date of creation of the account are irrelevant to the court's analysis. So she says what matters is what was true the moment the account was created. Anything that happened after that point is totally irrelevant. Okay. Ms. Gutman does not point the court to any legal authority supporting this proposition. Not that there's any, and there's not much authority supporting the opposite proposition because, again, it was invented today in legal time, but still. Nor does she differentiate or even reference these other decisions. So that's one thing she could do, by the way, because, you know, it's brand new law. So she could, if she's able to, which I don't know if she is, but she could try to distinguish. She could say, well, you know, this isn't the same thing as that because reasons, and you shouldn't uphold this standard court because reasons, and what those reasons would be, right? What are reasons that should be the law? What are reasons that shouldn't be the law? Right? Yeah, what are some reasons that should or should not be the law? Miss Gutman doesn't have anything. So, yeah, the court's probably going to be inclined to go with the other thing because it's there. The court's going to be like, but it's right over here. I could just use that thing, and which incidentally I'm going to modify slightly, or how slightly, questions emerge, but I'm going to modify, and you don't have any reason I shouldn't. So, okay, that's as good enough for me. This is how law gets created. This is fun. You're actually watching law get created in real time before your eyes. That's really cool. At least it's cool to me. I think it's awesome. Miss Gutman's unsupported self-serving position is unpersuasive. She doesn't really have great reasons, so that's a problem. The court adopts the multifaceted approach utilized by these other courts. The court could do something else. It doesn't have to. But the court looks at it and be like, well, that sounds good to me. And Gutman doesn't have anything better, so why not? Why not indeed? In evaluating the parties' likelihood of success on the respective claims of ownership of the account at issue. That's how badass this is. That's how cool, or interesting at least, common law is, right? Because the very thing we're trying to decide at this exact moment, mind you, is likelihood of success on the merits. The likelihood of success on the merits, of course, turns not only on the facts, but the law, right? Because all the facts in the world don't tell you anything without a standard to measure by. Because the standard could be anything. It could be lots of different things. The facts don't tell you anything. You need the standard. You need to know what you're measuring against. You need the scales. Without the scales, all the facts in the world don't do you any good. So is she likely to succeed or not? Well, we have to weigh them on the scales. Well, where are the scales? Oh, they don't exist. Oh, that's okay. I'm going to create them, says the court. There are no scales. No problem. I'm going to just invent them from nowhere. Not quite nowhere again, because again, there is some precedent, and that precedent itself was based on precedent, which was based on precedent, which was based on precedent. Reasons by analogy all the way down. That's turtles all the way down, people. But as to this exact standard, well, what's the likelihood of success? I don't know. In order to determine that, I have to know what the scales are. That's cool. I'm just inventing some scales now. Oh, look. The scales say that JLM wins. Now, I think that's badass. I think that's cool. That's common law. Right? Because the legislature doesn't have a specific answer. That would be great, incidentally. If the legislature had written some specific law dealing with this, that'd be nice. But they didn't. So someone has to decide who wins. Well, guess what? It's the courts. Based on reasoning by analogy, by analogy, by analogy, by analogy. And by the time you're done, you wind up in some case in 1300s or something. This is cool. This is cool. Ms. Gutman's attempt to narrow down the court's inquiry to the moment the account's created is overly simplistic, and the dynamics of social media warrant a much fuller examination of how the accounts were open to the public, the purpose for which the accounts were used, and the methods by which they were managed. That's basically a conclusion of law, by the way. That's just a, like, these things are good. Why are they good? Well, kind of because I say so. Because I'm literally the judge. For the following reason, the court concludes that JLM is likely to succeed proving its own, or at least minimum, has the right superior to any of right used by Gutman. And then they're going to go through the factors, which we've kind of already discussed, to be honest, so we'll kind of skim through it. First, the accounts were held out as official accounts of JLM. They created the accounts using Miss Hayley Paige shortly after signing the contract, which transferred to JLM the right to use variations of her name and trademark registration acknowledging the same. This factor weighs heavily in finding the accounts are business assets. JLM also utilized the accounts to identify its products, incorporating the handles on hang tags of physical garments. These descriptions displayed referenced the Hayley Paige brand and linked JLM other platforms. The Instagram account was linked to JLM's Facebook account for periods of time, regularly included a link to JLM's website, including as early as 2015, and frequently featured email addresses of JLM's public relations department. At times, the Instagram account also linked directly to the specific page of JLM's website to allow followers to access information about upcoming trunk shows, as well as JLM's other internet presences featuring projects or collaborations. Please take note here, the court is now applying the facts to the legal standard it just invented. That's pretty cool. Gutman argues the biographical distinction used by Instagram accounts supports her position she owns the account. Gutman provides a photograph of the account from 2020 and argues the inclusion of the phrase personal and creative account demonstrates the account is her personal asset. The court, however, finds this language to be of little significance in light of the 2019 breakdown of the parties' business relationships during their ongoing contract negotiations, leading Gutman to change the Instagram account password to block JLM's access. So sure, that fact is true. It just doesn't matter that much in my weighing against the standards I'm inventing. Her identification of herself as designer, she acknowledges her role as JLM employee. Gutman also argues the Instagram account verification in 2017 as an account a public figure demonstrates the account's description she indicates she owned the account. The record, however, establishes this status was achieved as a result of invitation by Instagram, likely prompted by promotional activities on the account. So that was Instagram who did that, which, you know, amazingly enough, is not going to bind this court's decision. Instagram's determination is interesting and all, but, you know, not a court decision does it make. Based on the foregoing, the court finds the evidence strongly supports the conclusion. The accounts were held out as business accounts. The fact that the accounts were created using the brand name, the rights to which were assigned from Gutman to JLM, the accounts incorporated links to JLM's internet presence and reference to JLM's products and projects, constitutes particularly compelling evidence that it's business assets. Then we've got the fact that it was regularly utilized to promote JLM's business, which we've discussed. The evidence demonstrates that the Instagram account also played a critical role as a communication platform to the customers and in response to customer service. In support of her position, Gutman argues conclusory arguments based on piecemeal selections of content, that the vast majority of the account reflects personal content. The record does not support the contention the vast majority of the content could properly be characterized as personal. Much of it was related to or depicted JLM's products, and JLM's strained attempt to characterize such material as personal is self-serving in the context of her contractual relationship with JLM. So are those posts personal or business in nature? Well, that's a factual determination. So, you know, they're a business. Gutman asserts, for instance, that even where I post about my work, which is a big part of who I am, that's still a personal post. Posts featuring JLM's designs, upcoming trunk shows, and promotional codes can hardly be labeled personal when they're inexorably tied to boosting JLM sales, revenues, and brand visibility. Moreover, many of the other posts that Gutman classifies as personal, including items showcasing her fashion interests or events going on in her life, including her engagement, reflect the subtle kind of marketing that social media is known for. So even her truly personal stuff is not really personal because of the nature of the marketing that social media is. And we have statements from Gutman that seem to reflect that understanding as well. Indeed, Murphy's credible testimony explained the sort of personalized touch of somebody close to the same age as the brides was a key feature of the marketing approach of JLM. Miss Gutman admits the approach of combining JLM's products with her personality is what made the account successful and what attracted followers to the account. The court recognizes that some of the account and engagement between Gutman and followers was more attenuated from her role. So it's not 100%. We're not saying that as the court. We are not concluding that everything on the account was business related. We'll give it to you, Gutman. Some of the information, some of the account was attenuated. Sure, why not? And incorporated reference to friends and family. Okay. So yes, there is some stuff the court finds to be personal, purely personal in its nature. The court found plenty of business stuff, and yes, we found some stuff that we're going to say is purely personal in its nature. These are findings of fact. How shall we balance the facts? When the context of the account is examined holistically, however, the content of a more personal character does not outweigh the content geared toward Gutman's marketing of GLM products, nor the tight but subtle marketing in which she associated the girly, whimsical aspect of her personality with the brand. Rather, the clear weight of the evidence is that they conceived of the brand as an extension of her personality, so her brand is her personality to some degree, making it even harder to separate, but then again, that was you. And helped JLM market and build its overall brand. Thus, evidence for the purpose of which the account were utilized strongly supports JLM's position that they're business in nature. The weight of the evidence suggests a business purpose, mind you, on the scales that I just built like 5 paragraphs ago, which I think is wicked cool. Third, the evidence demonstrates that JLM's employees were involved in formulating accounts, blah, 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 blah. Although Gutman actively participated in creating the accounts, engaged with Instagram followers, and maintained the log information, this evidence suggests at most that Gutman acted as JLM's project lead for management, just as she was lead designer for the brands, which deliberately associated her style and her personality with the brand. You've made them inseparable. Yeah. The evidence shows Gutman also served as a point person for the accounts, brainstorming ways in which the account could be used to promote the brand, delegated assignments among team members for the account management, and advocated for the account's importance to JLM. Yeah. The court therefore concludes, based on an analysis of the above factors, that JLM has established clear likelihood of success in demonstrating she owns Instagram. Yeah. To the extent that Gutman relies on arguments outside of the multi-factor framework. Okay, so taking notes, by the way, the court is now being very self-aware, which is good on the court. The court is being very self-aware. The court is saying, okay, you're making arguments also outside the framework, which is cool and all, because again, the framework is the one I'm inventing just now. In view of what other courts have done, limitedly in this domain specifically, and more generally in personal property in large, but still, the law is a little unclear. So you're making arguments outside the structure I created 5 seconds ago. I'm taking note of that, but still, it doesn't help you. So there are arguments outside that structure, but no. Gutman posits the JLM employees referred to the accounts as personal accounts, confirming she owns them. Sure, why not? But the court does not find this persuasive. The examples proffered by Gutman of employee references the account. The entirety of the evidence showed the accounts were referred to differently in various contexts, including by Gutman, as are accounts. So there was some mixed messaging. There might have been some statements from JLM or their employees that it was her account, but of course that does not necessarily solve the problem. As we've noted, Gutman has referred to it both as our accounts and my accounts, and JLM is in a similar position. And one of the email references, Hayley's personal Instagram, was made in the context. So one of the references, this is cute, one of the references to Hayley Paige's personal Instagram. So it uses the phrase Hayley's personal Instagram, but it used that phrase in the context of dividing assignments on the account among JLM employees. So, yeah. The court declines to attribute significant weight to descriptive labels used to refer to the accounts. So these intermittent references that it's your account is not going to do it for me, says the court. In addition, to the extent Gutman argues JLM's use of the accounts after the TRO was skewed, which has been skewed towards standard marketing content and suppressing certain aspects of customer engagement, undermines the position. So, hey, court, after you granted them this TRO, and this personal injunction, JLM changed the behavior of their account. They weren't doing it the same way anymore. It's now more of a traditional marketing apparatus than it was before. So that undermines JLM's argument. Their behavior shows they didn't really think that because they've changed their behavior. Well, does that change the analysis? The court finds the shift to be a very limited of any probative value. So no, because Gutman herself has been unable to cooperate and actively work to undermine it. So JLM's shift, to the extent it exists, is both minor and also predicated on the fact that you yourself are not only not participating, but trying to actively undermine it. So JLM can't use the asset anymore the way that they used to, or necessarily even the way they want to, because of you. And you can't bootstrap yourself into an argument like that, right? You can't, on your own bad behavior, win. That doesn't work. You're the one causing this problem. Shortly after the TRO was issued, Gutman issued a public announcement saying she'd no longer render services to JLM, and since issued statements portraying JLM in a negative light. The court therefore notes, JLM therefore has a legitimate business interest in taking steps to manage the accounts in ways that are responsive to these events in order to manage its reputation and promote its products. So yes, it's less of a personal account with respect to you, and you're in large part due to that, and JLM has changed the account in large part because of you. So we're not going to allow you to gain control of the account based on what you did, because it's you. Gutman argues that JLM cannot establish ownership of the accounts because there's no provision in the agreement that provides for JLM to receive ownership over the social media accounts. So this is back to a contractual argument. What is the nature of the contract? What does it mean? What does it mean? What is the contract? What does it provide for, and what doesn't it provide for? Someone's got to interpret the contract. So, yes, it's true, I suppose, that it doesn't really mention social media by itself in some way, but as the court has previously found, JLM has demonstrated the content constitutes work for hire pursuant to 11. So it doesn't really deal with social media exactly, but the nature of the work, the fact that social media is neither here nor there, says the court. It's work for hire. So the contract doesn't say anything about social media, but does say something about work for hire, and this is work for hire. So I'm good, says the court. Makes sense. Plaintiff has the exclusive right and license to use in commerce related to bridal goods what she designed, and to use the account to attract public to the gowns. This analysis also applies to compilations of content featured. Thus, looking at the language of the agreement, the court finds JLM is likely to succeed in demonstrating it owns the accounts themselves and not just the featured content pursuant to Section 11. So there is potentially a division there, right? There's the issue of, do you own posts, for lack of a better description, do you own posts on the account versus do you own the account? These are potentially separate questions. But the court thinks ultimately they're going to be resolved the same. The court is not going to split it, on these facts at least, between the posts on the account and the account. Please take note, of course, a different court in a different factual situation could split the difference. But the facts, at least the way this court finds them, according to legal standard the court thinks is appropriate, thinks that those questions are going to be resolved the same in this situation based on these facts. Note, the court is not strictly speaking at this point saying that that is a finding, because we're at this point on a likelihood of success, right? So the court isn't saying who's winning. The court is saying who's likely to win. And is it likely enough for JLM to win? So JLM could theoretically still lose, but there doesn't seem to be any indication of that at this point. So, I mean, we haven't had a full statement of facts, right? We haven't had a trial yet. We haven't had a jury yet. So something could change, but doesn't seem like we're going in that direction. Okay, blah, blah, blah. The court also concludes JLM has established clear likelihood of success on this conversion, which basically requires, so not only do they own it, which is one thing, but also that Gutman has converted it. So their ownership is required, but also that Gutman has interfered with their ability to use their thing, which we do have a lot of evidence for. So not only do they own it, which is a finding, but also that they've converted it, which is also a finding. The court's not finding that yet because we're not at a jury trial. We haven't had all the witnesses testify. We haven't had a full examination of all the evidence yet. But on a preliminary finding, who seems likely to win? Yeah. Seems to not be going well for Gutman so far. But stranger things have happened at trial, so you never know. So, and then the court says, okay, I'm also not, because I've solved the issue on conversion, I'm not going to analyze the trespass to chattel claim, which is interesting. The court's being a bit lazy, but, fine. I found a reason to dispose of the issue, so I'm not going to move on to anything else. Okay, so what am I going to do about all that? All right, so I'm going to modify the proposed relief with respect to paragraphs 1 and 2 to limit it to Instagram and Pinterest account rather than giving all social media accounts listed in addendum 1 to the preliminary injunction. So I'm only doing this right now with respect to the Pinterest and Instagram accounts, not other social media accounts. Cool. JLM does not allege in connection with this motion practice JLM currently has control over any other social media accounts, which the court has previously determined are marketing, nor does she gain unauthorized dominion over the accounts. The court therefore finds injunctive relief to be unwarranted and unnecessary. Well, because they're JLM's. So I can't really give you injunctive relief because they're already yours. So you kind of already win. So yeah. And then we go into whether or not there's irreparable harm or not, which, fine, because it deals with their intellectual property assets. So if this was given to Hayley Paige Gutman, Hayley Paige Gutman might say very disparaging things against JLM, which might be very difficult to recover from. Balance of equities, blah, 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 blah. Yeah. Carol Johnson says, Kurt, good luck tomorrow, kick-ass. Thank you very, very much for that kind super chat. I really do appreciate it. Thank you very much. Gutman, on the other hand, freely bargained for the contract with all of its benefits and burdens, and is not prohibited by paragraphs 1 and 2 from working as a bridal designer. She's simply unable to use the accounts or divert goodwill. So, yes, when her non-compete provision is over, which I believe it is at this point, she can work as a bridal designer. She just can't use her name in the business. So if she wants to sell dresses, she's going to have to call them something else, because she sold her name in a bargain for contract. So, yeah. Accordingly, we've demonstrated likelihood of success and blah, 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 blah. We also want a new injunction about the trade secrets thing, which I'm not sure. Yeah, I guess. I mean, you're bound by that anyway, because the contract itself says it's perpetual. So, yeah. Neither party disputes that JLM applied for and received registration of trademarks. The parties dispute the meaning of the provisions, which, fair enough. But as to what the language of the contract means, it's a legal question, right? So what does the contract mean? What does the contract say is a legal question, not a jury question. The jury figures out what the facts are once we determine what the contract is. So if there's a dispute about a meaning of the contract once it's established, then the jury. But the court determines whether or not there's a conflict, because it's a question of law. So we look to any ambiguity that will emerge, must emerge within the contract itself. It's not ambiguous if it has precise meanings. We therefore begin with the text. It unambiguously prohibits Gutman from identifying herself in trade, in competition, by using her identity as Gutman, relating to her name. Gutman argues the scope is limited to that of the name or any derivative thereof, and would not be implicated if she was to compete with JLM publicly or otherwise under a different name. Well, the contract says otherwise. Section 10C does not limit itself to identification, but designer's name, but rather prohibits entirely the identification of the employee as a designer in competitive goods. So the non-compete provision continues to apply for 2 years, I believe. Non-compete provisions have to be reasonable. And 2 years is probably reasonable. So yeah, not so much. So the language prevents you from acting as a designer in any cooperative, any competitive enterprise under any name. So you can't compete against JLM as a bridal designer using any name at all of any description. Other kinds of clothing, maybe, but not in the bridal design, because that's the non-compete clause in the contract you signed. Blah, 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 blah. I've considered your arguments about the whole trademark thing, but no, blah, 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 blah. I've established clear likelihood of success. That would breach the restriction. Gutman has conceded that she's ready and willing to use a new name in connection with any future brand, collection, or business endeavor, and express this desire publicly to re-enter the bridal industry under a different name. That's the problem. She can enter the clothing industry, but she can't enter the bridal industry while her non-compete is in play. Gutman, whose face and reputation are well known within the bridal industry, print media, and personal appearances, stated she plans to announce her new brand name soon and return to the industry she loves, and was planning a gorgeous return to work. Nope. JLM has also proffered evidence that customers seeking her designs have expressed a desire to direct their purchases to this new brand. So people want to buy from her. Not so much. When as here, an individual's public reputation has been carefully built and widely publicized as designer of the specific type of goods, and the person is served as the face of a namesake brand, implicit identification as a designer through identification of the brand is effective as to marketing and would damage the company's goodwill and contractual rights, no matter what title she might claim. It's your face, babe. That's the problem. So no. The court will not wait until there's a breach, because while Gutman has already pretty much strongly telegraphed she's planning on competing, she's made lots of public statements. This is like anticipatory contract breach, basically. Gutman has made lots of statements that seem very clear that she wants to re-enter the bridal industry designing game under a different name. And JLM has presented evidence that people want to buy from her. So it seems like she is dead set on this. So I suppose we could wait until actual breach, but it seems like we have enough information for an anticipatory breach. So we're not going to wait. No. So, no. How about now? Miss Gutman has announced publicly her intention to re-enter the bridal industry in competition with JLM on August the 1st. In absence of an injunction, her public announcement of upcoming competitive brand in June 2021 prompted a strong positive response from her followers, who expressed their intention to wait for the new product line to be released instead of purchasing products from JLM. Should Gutman be permitted to implement these plans, JLM would suffer loss of sales and loss of goodwill in the brand, which would be very difficult to quantify. Money will not necessarily fix this problem. Moreover, JLM's ability to market the Hayley Paige brand to vendors and consumers would be irreparably harmed, as vendors and consumers would be able to immediately identify the person they recognize as Hayley Paige, who is the featured persona of the brand, with her forthcoming collection endeavors, no matter what new name she uses. We think that people are going to be able to figure it out. The extensive public promotion of Gutman as lead designer and face of the brand, including by associating the brand with her name, her taste, her voice, her vision, her face, and her mannerisms, make it likely in the short term that consumers of the brand would be very likely to seek out products as promoted by, for example, a girl you know. So if her brand was literally called A Girl You Know, we still think people would probably figure it out. So that presents a problem. Blah, 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 blah. Blah, 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 blah. Thus, injunction. Not so much, Hayley Paige. Not so much. You will not on August 1st launch your new brand. You will not on August 1st announce your new titles. You will not enter the bridal industry. No, not so much. Not for you. Because the non-compete clause didn't end with your contract. By the contract's own terms, it lasts for another 2 years. So you can pencil in that August 1st, 2024 date. And yeah. But if you want to design clothes other than bridal design, you make sure to let us know. Yeah. So, yeah. We want to extend the terminal date of relief by 1 year and 8 months. Yeah. Yeah. So, we're going to deny this injunction. So, what this one is we want to extend the terminal date of relief of 3B to replicate the period of issuance, which prohibits from competing during the contract term. Oh, so are we not doing this? Are we not doing this? We're denying an extension of time past the date. Okay, so are we not extending out the non-compete clause? I might have confused myself at this point, and I want to make sure I get it right. So it looks like maybe we are not extending out the non-compete clause. So maybe so much. Maybe there's hope for Hayley Paige. Maybe all is well again. So where am I? I'm on page 51 of this thing. Let me go back up to the actual original contract language. Let's see. What did it say in the original non-compete? During the period of employment. That's where I made the mistake. I thought there was a 2-year add-on. So in the contract language, because this thing is being driven by the contract, of course. So in the contract, the employee covenants and agrees during the period of employment shall not compete. Blah, blah, blah. During the period of employment, we shall not compete. Blah, blah, blah. So the court, in doing the multi-factor analysis, found some of the factors to be true, but is having problems with other of the factors. And the court does have to find every single factor. So I made a mistake by leaping ahead. My bad. Hayley Paige Gutman might be coming to a bridal show near you very, very soon. So let's see. Where were we? We're on page 57. We're on page 50-something of this thing, I think. Let's see. Where were we on this non-compete clause thing? Okay. All right. So request to extend relief. All right. So JLM requests to extend the terminal day of relief granted by paragraph 3B of the paragraph injunction, replicating the period of time from the issuance of the TRO until August the 1st. Paragraph 3B of the preliminary order was imposed to prevent imminent and irreparable harmful violations, which prohibit Gutman from competing with JLM during the contract term. JLM argues the extension of relief is warranted as an equitable remedy. So they're not arguing it's in contract, they're arguing in equity. So the court is probably going to say no. The court declines the request for extension beyond August the 1st, which coincides with the expiration of the date. So they therefore decline to impose the additional sanction for past misconduct. Moreover, as designed in 10E of the contract, which the contract will enforce, provides substantial protection. So it looks like Gutman can, in fact, compete. Not so much with using her name, if I'm reading this correctly. Yeah. So not so much for anything she designed or created or using her name, but anything she creates brand new, she can compete with JLM. So look forward to a post from Hayley Paige Gutman in the very near future about her new line, but not so much with her name, though. I guess we'll see how well she's able to do using a different name. Okay, so conclusion. We do all those things. So during the pendency of the action, Gutman, along with her officers and employees and blah, 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 shall not do any of the following. Make any changes to the Instagram account or Pinterest account, including changing the name of the handles, deleting, altering content, transferring accounts, blah, 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 blah. Taking any notice other than properly noticed action to gain control. Breaching the employment together by doing any of the following things. So you can't do these specific things. Using or authorizing others to use Hayley Paige Gutman, Hayley Paige, or any derivative thereof. So you can't use your name until August the 1st, which is coming up rapidly. Associating with any person engaged in bridal apparel design that's not manufactured by JLM. Using any of the designs or trademarks owned by JLM, so nothing of the work you produced for JLM, and until August 1st or 2027, being identified to the trade or consuming public as designer of any goods in competition with goods manufactured and sold by JLM, or using or authorizing others use her role as a designer to promote her sale or goods in competition. So we have a very kind of specific non-compete order. This is a very weird non-compete agreement, but it's being driven by the agreement. Okay? So this is also part of my confusion on the whole thing. All right, so here's what she can do and what she can't do. Starting August the 1st of this year, she can, in fact, go forward into the world and start competing, but she can't use her name. She also can't do anything until 2027 that would identify her as the designer of any goods. So she can sell a product not using her name, not indicating that she's the one designing it. But she can design the product, so I suppose the product will very much rise or fall by its own merits, because she can't identify herself as the designer. So, yeah. And she can't use the role as designer to promote the sale or any goods. So she can enter the industry, she can make bridal goods, but she can't use her name, and she can't mention that she's the designer until 2027. So, not going great. And that is the end of that. So things are not going great for Miss Gutman. So I don't know how. So yeah, I guess I guess you will not be hearing on August 1st of 2022 an announcement from Hayley Paige about her new brand, because that would identify her as the designer. You might hear a post from somebody on August the 1st who may or may not be Gutman, because one would imagine other people might make posts that day. So I guess you'll have to guess whether or not it's Gutman or not, if you're into that kind of thing. So, yeah. Yeah. And it seems, someone said it seems like terrible in overreach. Well, everything's being driven by the contract. Everything's being driven by the contract. Right? So if we go up to the non-compete provision and we go back up to the contract language, we have this non-compete provision, which we read earlier. But let me make sure. Yeah. Here's where this is kicking in. Okay. So we got two provisions of the contract. Okay. And this is all being driven by the contract language. So why is this overbroad? Because the contract language says it. So this is all being driven by the contract. Like, the court is not making this up out of nowhere. This is in the contract. All right. So we got two provisions in play. We got provision 9A, which is the covenant not to compete. You agree that during your period of employment, which ends August the 1st, you will not compete with us. You will not engage with any person, enterprise, or organization that does bridal apparel, bridesmaids, mother of bride, flower girls, bridal accessories, evening wear, or any other category of goods designed, manufactured, licensed, or sold by the company. All right, so that's one provision, the non-compete. But the non-compete provision ends when the contract ends, which is August the 1st of 2022. But there's another provision in the contract, and we have to give every provision in the contract its own language. And so in effect, so we also have 10E, post-contractual term covenant. In the event that the company files an application to register trademarks or trademarks, employee agrees that for a period of 5 years following termination of her employment, she shall not be identified to the trade or consuming public as the designer, and her role as designer shall not be used to promote the sale of any goods in competition with goods sold by the company. So that's just plain language of the contract. I mean, it's hard to read that much any other way. The company did, in fact, file trademarks. So she has agreed for 5 years, she shall not be identified as the designer, and her role as designer shall not be used to promote the sale of any goods in competition with the company. So the reason the court is coming to these harsh sounding decisions is because it's what the contract she signed requires. And of course, everything is being driven by the contract. So yes, you can compete. No, you can't identify yourself as the designer, because that's what the contract says in black and white that you agreed to. So, yeah. How did her lawyer let that provision through? I'm not sure whether or not she had a lawyer or not. I don't know for sure. I'd have to double check. But it's quite possible she didn't have a lawyer. She's an adult. She can sign a contract if she wants to. At best, JLM has to give her some opportunity to consult a lawyer. They don't even necessarily have to advise her of it. At best. So I don't know whether or not she had a lawyer who helped her with this contract or not. Maybe she didn't have one. Maybe she didn't get a lawyer. Maybe she signed on the dotted line without understanding what she was reading. She's an adult, though, so, oh well, that's unfortunate for you. Do you have to have a lawyer read over your contract with the cable company? Exactly right. Yeah. No. Yeah. So maybe this is a little different than your contract with the cable company, but, you know, at best, they have to give you an opportunity to consult with a lawyer, but they don't have to tell you that you should. So your only possible argument is basically that they said, sign it now or the deal is gone, which would be like undue pressure or undue influence, right? As long as they gave you an opportunity, and they don't even have to make it explicit, by the way, right? Your only argument basically is they said, sign the deal now or it goes away. If that was the case, then great. But if they just said, hey, would you like to sign this agreement? And they didn't say that, and you didn't ask if you could consult a lawyer, and they didn't say you couldn't consult a lawyer, as long as they didn't tell you you couldn't consult a lawyer, it was on you to ask. It was on you to invoke your rights. It wasn't on them to tell you. They gave you the contract. As long as they didn't say some version of, you can't consult a lawyer, well, you're an adult. You're bound by the contract you sign. Kat says she had one. Okay, well, either way, you know, how did the lawyer let her do that? Well, my role as a lawyer is to give you advice. I can't stop you from signing things. All I can really do is like tell you what things mean. So assuming she had a lawyer, her lawyer's role in this is to explain what she's doing and to potentially figure out whether or not the client is okay with that or not. It's up to the client to determine whether or not they're okay with it. My role is simply to tell you what you're doing. So if you come to me as a lawyer and you say, here's a contract someone wants me to sign, my role is to say, well, here's what you're doing. If you think, oh, that's a problem, what's possible? Then I might say, okay, here are things we can negotiate over. Here's things we could try. You know, here's whatever. But if you're like, hey, that's cool with me. I mean, you're the adult, you're the client. I, as the attorney, can't stop you. If you said, I'm cool with this agreement after I explained it to you, it's not for me to stop you. You're an adult. I mean, I can say maybe you shouldn't do that, but, you know, it's up to you. You're the client. I can't stop you. Yeah, as long as they didn't extort her, right? So, like, yeah, there are other reasons you could nullify the contract, right? Extortion, fraud in the inducement, fraud in fact, undue influence, unconscionability. So there are other reasons that you could, like, nullify the contract, but we're not talking about any of those right now, so, yeah. But as long as they're not hiding the ball, which seems like it's pretty clear on its face, language isn't, like, so opaque you couldn't understand it. It's like if you read it, you should be able to understand it, and if not, hire a lawyer. But it seems pretty plain language for these kind of things. So I don't know whether or not she had a lawyer or not. I don't know whether or not her lawyer told her it was a good idea or not. I don't know the degree to which they negotiated or not. But as long as her lawyer explained it to her and she agreed, her lawyer's in the clear. There are some people who do what they think is right and scream later. They're the smartest, dumbest people in the world. And Amber Heard has proof clients don't always listen. Yeah. So her lawyer has an obligation. Her lawyer's obligation is to explain it to her and make sure she understands it. Her lawyer might have, but is not obligated to, express an opinion about that. So as long as her lawyer explained it to her, he's good. If the lawyer then also on top of that said, I don't think you should, or whatever, then, well, okay, but you're the client. You understand what you're doing, which is my role. Go forth into the world, young friend. Hope it works out. It didn't work out. You know, so we are in no position, based on the facts that are presently available, to conclude her lawyer did any kind of malpractice. Of course, it's possible that our lawyer did some kind of malpractice, but we have nowhere near, basically we have zero facts that would let us draw that conclusion. We have no evidence to that conclusion. So, I mean, we don't know. So, yeah. Cosmo said she didn't hire a lawyer. Either way, it's like, as long as they didn't trick her, as long as they didn't say you couldn't hire a lawyer, as long as they didn't lie to her, as long as they didn't put some undue pressure on her, as long as there was no fraud, which there doesn't appear to be, she's an adult. It's up to her. If she's like, ooh, contract, sign. Well, this is where we're at now. You might want to hire a lawyer when looking at these agreements. Yeah. So at least you understand what you're doing, which may be the right decision for you, incidentally. I'm not going to state that this is a bad deal, like from the beginning. I don't know. If you were a lawyer coming to me with this in the first place, what would my advice be? I honestly don't know, because I'd have to think about what position she's in and what the benefit of the deal is. So maybe this was the right deal for her, because her success is somewhat of an unknown, presumably, at the time of the contract. Let's at least go with the premise that her success is somewhat unknown. We don't know whether or not she's going to pop, and most people won't. So maybe it doesn't matter that she's selling her name, because her name is going to be of no value. So she's not really selling anything. But, the cosmic dice are just such that, it turned out that she was one of the lucky ones, or not, depending on your point of view. And so we are where we are. So if she walked into my office as she was, so many years ago with this deal, what would my advice be on whether she should sign it or not? I'm honestly not sure. I'd walk her through hopefully, I'd walk her through the potential ramifications of it, but I don't know what advice I'd have. I'd have to really think about it. And I don't know what advice her attorney had, and I don't know that it was bad advice. Just because things panned out a particular way doesn't mean that the advice was bad in the first instance. Both parties were taking something of a gamble up front. Who was gambling more is debatable, but both parties were gambling. And, well, there you go. So it's hard to know. It's hard to know whether or not it was a bad deal at the very start. At least it's not inherently obvious, it seems to me. So, I don't know. Yeah. And again, my power as a lawyer, even assuming it was bad advice, even assuming it's bad, my best thing is you shouldn't do this. I can't stop you. So, yeah. Is it not a standard contract she signed? I don't know the degree to which it's standard or not. I honestly don't know. I can't answer that question. It may very well be a standard contract. I don't know. I don't know the degree to which this contract was. Well, no, it can't be a standard contract. It's not possible, because the contract specifically mentions her by name in Section 10A. So it might have parts of it that are standardized, but it is not a form contract, because Section 10A specifically calls her out specifically by name. So this contract was specifically designed, at least in part, for her. I can't speak to the degree to which other people have contracts that are very, very similar to this, but this contract was created for her. I don't know the degree to which the company has similar language in other agreements with other people. I don't know the degree to which, I honestly don't even know the degree to which she negotiated over language. In fact, if memory serves correctly, and it's been a long time, but I think she did negotiate over the language. I'd have to double check. I'd have to go back into the original pleadings and stuff. But now that you're mentioning it, I seem to vaguely recall that there was negotiation over the language, at least to some degree. I might be having a conniption over here, but I think that might have happened to some degree. So I don't think we're in a position where this is a take it or leave it agreement, which incidentally, when automatically make it unenforceable anyway. So all those things. So yeah. So a new bridal design company may be launched on August 1st. So if you're fans of Hayley Paige, I guess, look for Instagram and look for Twitter, and look for any bridal design companies that are announced on August 1st, and you'll have to deduce whether or not that's Hayley Paige or not. And it wouldn't surprise me if JLM announces a new line on August 1st and not make it clear it's JLM's line, because there's nothing stopping them. So I don't know how smart or how well ahead JLM is thinking, but there is nothing stopping JLM from announcing a new bridal design line on August 1st, or potentially multiple different lines on August 1st, without making it clear that any of them are JLM. Who are they? I don't know. So maybe 10 people, maybe there will be 10 announcements on new bridal lines on August the 1st. Which of them is Hayley Paige? I don't know. Guess you'll have to figure it out. Hope you guess right. How smart is JLM, I guess, is an operative question here. So yeah. Because JLM knows that there's interest in a line designed by Hayley Paige. They know there are customers out there that want things designed by Hayley Paige. So, and they also know that Hayley Paige can't announce herself as the designer. So maybe JLM announces a couple new bridal lines on August the 1st without making it clear that any of them are JLM's. Who knows? How smart is JLM is the question right now. Can she say she's the owner or curator of the company in order to get around being the designer of the company? See, this is the kind of thing that the court is going to whack you over the head over. You don't want to play smart with the court, particularly in view of an injunction. And you're like, they say I can't be the designer. Can I say I'm the owner of the company? No, because everyone understands that means you're the designer. Right? Well, I didn't say I was the designer. I said I was the owner. Yeah, that kind of subterfuge is not going to work, right? We all know what we're really talking about. So that's a way to get a contempt sanction by the court fast. So I would not recommend, if Hayley Paige was my client, I would not recommend. Be like, it only says designer, but I'm saying owner. That's totally different. I'd be like, that is not totally different. You're going to have a bad time. You're trying purposefully at this point, mind you, to get around the court's order. The court is going to whack you over the head. So I wouldn't try that. I'm not saying she won't do it. I'm saying if she does do it, a contempt motion will soon be in the works. So, yeah. Can she name the company after her mom or someone related to her? This is where things get tricky as a lawyer, right? So you're asking me basically, what can I do that's in compliance with the court order? And so, like, I can't use, well, I don't know. I'm not, that would be tricky because I'm not allowed to use Hayley Paige Gutman, Hayley Paige, or any derivative thereof. That seems to cover a lot of ground. I suppose you could argue that her mother is not a derivative of her name because she's a derivative of her mom's name. But again, you're playing fast and loose here. What you're trying to do here is get around the court's order. And you need to be very careful about how you do that if you're going to try to do it at all. Because courts really don't like that. and you're on your way to a contempt sanction. So I would be highly cautious as if you came to me, if you're Hayley Paige, and be like, can I name the brand after my mom? I'd be like, how many people know who your mom is, and how similar is it to your name? Or your sister, or like whatever. It's like, how similar is it? So again, this is something you want to think really, really carefully about before you do it. And you might even consider getting the court's permission first if you're going to go down that line. This might be one of those situations that asking for forgiveness rather than permission is not a great plan. So if you're going to try to purposefully skate on the edge of the court's order, you might want to seek the court's permission first. I know there's a decent chance they're going to say no, but if you do it anyway, you're going to get whacked over the head, and it's not going to be pleasant. So we might want to ask the court first if we're going to play on the razor's edge of the court order. So, yeah. Can she use Hayley Paige? I think Hayley Paige would be derivative. I think we can see, again, I think we can see through this subterfuge. You know, if it's an obvious subterfuge, you're going to have a bad time. So yeah. Yeah. You're going to have a bad time. So I would be highly cautious before playing fast and loose with a court order. That's something you would definitely want to run through your attorney through very, very carefully before you went and did things. And you might want to seek the court's permission first. What about a pet's name? Is the pet name derivative to you? See, as long as it's something that is completely unassociated from you, you're fine. So if your name of your pet is Spot, then cool. Lots of people have the name Spot as pets, so there's no particular reason to align it to you. If your name of your pet is anything even remotely close to Hayley Paige Gutman, no. So yeah, no. Designer formerly known as Hayley Gutman, no. I wouldn't necessarily recommend that either. I appreciate your guys' endless creativity in the chat as you try to circumvent the court's order. I will simply note, as an attorney, you are trying to circumvent the court's order. So if you are trying to circumvent the court's order, I would think real hard about that in strong consultation with a lawyer and possibly get permission first. Because you are playing with fire, my friend, and it might not end well. So yeah, I appreciate your immediate thoughts of creativity, but my immediate thought as an attorney is, well, I'm going to sign off for now. I've enjoyed this chat. I hope you have too. Things continue not to go well for Hayley Paige Gutman, largely because of a contract she signed, and it's not going well. And she may or may not announce a brand on August the 1st, which may or may not be announced along with other brands, which may or may not have anything to do with her. So, yeah. What if she went with court-ordered circumventer? See? No. No. Can she call herself HPG? Well, is HPG a derivative of Hayley Paige Gutman? I think so. So again, I'm going to go with no. Your guys' endless creativity is lots of fun, but no. All right, so as I'm sure you guys know, because we've talked about it a lot, the bar exam is tomorrow and Wednesday. So as a result, I will not be online tomorrow and Wednesday. Maybe in the evening, possibly, but probably not. So for the next 2 days, I'll probably disappear off the face of the earth as I'm taking the bar exam in Texas. So, yeah. But I will return eventually. So, my friends, until that time, I've been Uncivil Law. I hope all's well. Till later, my friends. Cheers and goodbye.